Welcome to the Law Office of Brian Fagan podcast, where we empower Texas families through knowledge and compassion. Today, we're focusing our explainer on a deeply important topic, especially if you're local to Tarrant County, parenting time attorneys in Fort Worth, Texas. More specifically, we're talking about protecting your time with your children. How does Texas actually decide when each parent gets time with their child? And, what can you do if the current schedule just isn't working for your family anymore? Parenting time is, without a doubt, one of the most emotional aspects of any family law case. So our goal with this explainer is to show you exactly how Texas courts focus on creating schedules that support a child's stability while fiercely protecting the rights of both parents whenever possible. Okay, let's dive into this. Here's a quick look at our roadmap. We're going to break this highly emotional topic down into clear, manageable steps. We'll start by decoding some specific Texas custody terms. Then we'll look at the child's best interest and standard possession orders. After that, we'll explore custom and supervised schedules, how to go about modifying your visitation order, and finally, enforcing your visitation rights. So let's start with Section 1, Decoding Texas Custody Terms. Texas family law uses some very specific language, so we need to translate that into plain English first. If you're navigating family court in Fort Worth, you'll hear the word conservatorship thrown around a lot. When folks in other states talk about legal custody, this is basically what they mean. But here in Texas, conservatorship is strictly about decision-making authority. It's your legal right to make major life decisions for your child, like where they go to school or their medical care. It's really important to understand that this is completely separate from the actual physical time you spend with your child. That brings us right to possession and access. This is the Texas legal equivalent of what most people simply call visitation or physical custody. When a judge issues a possession and access order, they're setting the precise schedule that outlines exactly when and where each parent gets to spend physical time with the kids. Now, circling back to that decision-making authority we just talked about, courts usually grant one of two main arrangements. Joint managing conservatorship, or JMC, means both parents share those major decision-making responsibilities. And honestly, Texas law presumes that JMC is best for a child unless there's hard evidence proving otherwise. On the flip side, we have sole managing conservatorship, or SMC. This means only one parent is granted the exclusive authority to make those big decisions, which typically only happens in cases involving things like abuse, severe neglect, or just extreme unmanageable conflict. Moving on to Section 2, the child's best interest. This is the guiding principle for every single Texas family court judge. Now, what's really interesting about this slide is that judges actually do not look at what the parents want. They look strictly at what serves the child's absolute best interest. To figure that out, they weigh a massive array of factors. They look at the emotional and physical needs of the child, the stability of each home environment, and each parent's active involvement. Things like who historically takes them to the doctor or attends parent-teacher conferences. They also factor in logistics, like the distance between homes, the parent's ability to cooperate, and crucially, any history of family violence, neglect, or substance abuse. That takes us to Section 3, Standard Possession Orders, or SPOs. This is basically the default schedule in Texas. So if parents can't agree on a schedule themselves, Texas relies on this baseline default schedule. The law presumes this is in the best interest of children over the age of 3. Let's break down how this actually works. Distance is a huge factor here. If parents live within 100 miles of each other, the non-custodial parent typically gets possession on the first, third, and fifth weekends of a month, plus Thursday evenings, alternating holidays, and 30 days during the summer. But if you live over 100 miles apart, those weekend visits might be reduced to just one a month, the Thursday visits usually disappear, and summer possession actually extends out to 42 days. Plus, you get every single spring break. Section 4, Custom and Supervised Schedules. Because, let's face it, one size does not fit all. While the standard possession order is the default, every family in Fort Worth is entirely unique. Courts totally get that, and they can and do approve different arrangements. If you and your co-parent agree, you can craft custom schedules. Maybe that's a week-on/week-off rotation or a 2-2-3 schedule where you alternate 3-day weekends. It's also really important to point out that standard rules don't automatically apply to infants and toddlers under 3. For the really little ones, courts often issue a staggered schedule that gradually steps up the non-custodial parent's time as the child grows. Now, in some situations, a standard or custom schedule just isn't safe. If there's credible evidence or a history of violence, abuse, or substance danger, Texas courts can mandate supervised possession. This means a neutral third party, maybe a designated family member or even a professional private agency, must actually supervise the visits. It's all about ensuring the child is fully protected from any physical or emotional harm. If you're searching for parenting time attorneys in Fort Worth, Texas, visit brianfagan.com or schedule a confidential consultation with our experienced family law team. All right, moving into Section 5, modifying your visitation order. This is our troubleshooting phase. Because the reality is, life changes, right? What happens when you get a huge promotion that comes with new hours? Or maybe you have to move out of Tarrant County? Or what if your child's needs just fundamentally shift over time? The schedule you agreed to 5 years ago might be a total disaster today. The good news is you absolutely have the legal right to ask the court for modification. To do this, there's a specific process. First, you have to prove there's been a material and substantial change in circumstances. Second, you have to officially file a modification case. And third, you must seek a judge's approval. And this brilliantly illustrates a massive trap a lot of people fall into. Verbal agreements between you and your ex to modify schedules are completely unenforceable. I repeat, unenforceable. The court will only enforce the last piece of paper a judge actually signed. You have to officially go through the court. Which brings us to our final critical section, number 6, enforcing your visitation rights. This is incredibly frustrating, but we have to talk about it. What do you do when the other parent just won't comply? Maybe they're denying your scheduled time, constantly returning the child late, or just flat out ignoring the transportation arrangements outlined in your order. First, we have to clear up a very dangerous myth. Some people think if the other parent isn't paying child support, they can just stop visitation. So the crucial point is this. Child support and visitation are completely separate legal issues in the eyes of a Texas judge. You absolutely cannot withhold visitation just because your ex is behind on child support. And conversely, you cannot stop paying child support just because they are withholding your visits. Doing either of these things can result in you being held in contempt of court, and you could face steep fines or even jail time. Let's look at a few other common mistakes you definitely want to avoid. Violating court-ordered schedules is a massive one. Repeatedly violating visitation orders is a serious offense under Texas law. Other big mistakes include poor communication with your co-parent, failing to document missed visits, always write it down or keep text records, and waiting way too long to request a modification when things change. But the absolute biggest mistake, putting parental conflict ahead of the child's well-being. Believe me, judges notice when parents use their kids as pawns. This is exactly why having a knowledgeable Fort Worth attorney is so crucial. They don't just stand up and argue in court. They systematically protect your parental rights and help you properly document issues. They work with you to develop practical possession schedules that actually fit your real life. They can resolve disputes through careful negotiation or step up and litigate if necessary. Plus, they know exactly how to navigate specific Tarrant County court procedures to successfully enforce or modify those existing orders. If you found this explainer helpful, please hit that subscribe button and share it with anyone who might need a little guidance right now. We are fiercely dedicated to helping Fort Worth parents protect their rights while promoting healthy, stable relationships with their kids. You can always visit brianfagan.com or call 281-810-9760 to speak directly with our team. Before we wrap up, I want to leave you with a question. Is your current parenting schedule truly reflecting your child's best interests today, or is it just a memory of what worked years ago? Don't leave your most precious time to chance. Thank you for listening to the Law Office of Brian Fagan podcast, where families find freedom and peace of mind through education and expert legal care. For more information or to schedule your free consultation, visit our website or call 281-810-9760 today.